Hey, welcome back to our monthly webinar series on ERISA and health insurance subrogation. It's just me and Catherine today. Nancy is out somewhere on assignment, probably doing some subro work somewhere. But this month we're kind of taking a step back. Rather than taking a deep dive into a series of narrow topics, we're going to be kind of covering the fundamentals of setting up a subrogation file, common issues with opposing parties, and some practical tips to kind of streamline your case and maximize your recovery. But to begin, I want to just start off just kind of catching everyone up on a little bit of ERISA terminology and kind of explain some foundational issues to those who may not be as familiar with it, or it just might be new to you. But again, feel free to chime in on the GoToMeeting question box. We'll try to check those throughout and maybe just work any questions in to the presentation today. Make sure we can address any of those fundamental questions that everyone might have. So, but just to begin, let's start us off with what the heck ERISA is. So it's it refers to the Employee Retirement Income Security Act. It's a federal law that was passed in 1974, and it basically governs how employers provide benefits to employees. So the law itself is pretty extensive, and it's been, aside from maybe the Medicare Act, it's one of the most confusing statutes out there. Just that there's a lot there. There's a lot of specific terminology. And it uses some antiquated terms that maybe we don't see every day. But the law essentially was established, it establishes requirements and guidelines for employers, plan managers, trustees, and others who provide services to those type of plans. The purpose really was to federalize or ensure minimum standards that would be set for a majority of the private sector pension and health plans. For example, under ERISA, employees must be notified of certain benefit plan terms, including funding, costs, coverages. Employees are also guaranteed protections against fiduciary wrongdoing and remedies. So plan participants or even the Department of Labor may be able to sue plan fiduciaries if certain plans or funds are mismanaged. And again, it provides ready access to the federal courts. But what exactly is an ERISA plan? It's pretty broad, actually. The Department of Labor defines an ERISA plan, just paraphrasing, basically any plan or program that is established by an employer or maintained by an employee organization, so like a union, which provides certain employee benefits through insurance or otherwise. So what we're talking about typically are retirement benefits, health benefits, life, disability insurance, mostly those so-called fringe benefits that employees are providing to their employers. Again, ERISA is trying to make it so the standards applicable to these type of benefits are uniform across the country, that we're not dealing with a hodgepodge of different state laws that apply even when we got employers that frequently cross state lines. But not necessarily all insurance that you might get through or think that you're getting through your employment is covered by ERISA. There are some safe harbor provisions that allow certain insurance or benefits to kind of exist outside of ERISA. And that those safe harbor rules are basically something that the employer doesn't endorse or contribute to. Employee participation is voluntary. Again, the employer is not really endorsing it, more basically just offering it to be potentially available. And again, the employer receives no compensation. The classic example is AFLAC. So you'll get maybe a notice that the AFLAC rep is coming next month, and if you want to meet with them, you can meet with them in the conference room or something like that. But the the employer is not contributing to the AFLAC, the employer is not saying you have to participate in AFLAC, and AFLAC doesn't pay the employer anything for offering its program to you. ERISA also, it's also important to know what certain groups fall outside of ERISA, because a lot of plans you might be handling are self-funded plans. We'll talk about that later, but that just simply aren't ERISA plans. They've got all, it looks like an ERISA plan, it looks like everything else you'll be handling, but they're not ERISA because they're covered by an exemption. So ERISA does not apply to church or religious plans or governmental entities. So frequently we'll see even like tribal governments are not covered by ERISA. Now there's a host of exceptions to this, depending upon how commercial the particular either tribal or maybe religious plan is. But just know that not every plan out there, especially if it's offered by a church or a governmental entity of some sort, is going to be covered by ERISA. Now turning to the language of ERISA, we use a lot of terms specifically. Most of them are found within the statute or the regulations, and they all have very specific meanings. So when we use the term plan administrator, we're not confusing that with a claims administrator. Those are two separate, often two separate entities, and they do separate functions. The plan administrator is very important under ERISA. It's at least from our standpoint, as lawyers, we need to know who that is, because they're often the plaintiff if we're having to file a lawsuit, and they are specifically going to be designated within the plan document, and they're the ones that are initially given the duties to process claims, interpret the plan document, exercise discretion, and frequently this plan administrator is also the plan sponsor, but not always. So the plan sponsor, again, that's usually going to be the employer or the union that is offering the plan. Potentially there might be some association plans that would fall within ERISA, but typically you're going to be seeing an employer or a union-based welfare plan that is going to be the designated plan sponsor. And again, often that plan sponsor is also the plan administrator. What's up with these plan numbers? You'll frequently see like plan 501, 503. Why do they come up with these numbers? Where do they get them from? And why does every employer seem to have the same plan number? So I looked into this a little bit just because I was curious, and it's not really a mystery. The Department of Labor kind of recommends that if there's one plan, that it should be numbered 501. If there's more than one plan, it should be numbered 501, 502, 503, 504, just sequentially like that. So, there might be multiple retirement plans, there might be multiple health plans depending upon where the employees are centered and whether they're in, an HMO type plan or whether they're, in a network plan. And so that's why an employer may have multiple plans, and that's why you're going to see that 500 number. Plan participant and plan beneficiaries. These are quite simply the employees that are covered by the plan, or in the case of beneficiaries, they're the dependents that are going to be designated by the participant or by the terms of the plan, and they're the ones who are entitled to receive benefits under the plan. What is a fiduciary? That's quite a key term. Frequently, there's maybe a thinking that the fiduciary is the plan administrator or the plan sponsor. That's the fiduciary. And while that's true, typically there's going to be a named fiduciary, and that oftentimes will be the plan sponsor or plan administrator. Fiduciary is not so limited in ERISA. So a fiduciary is really any person or entity that has some discretionary authority to control or manage the operation and administration of a benefit plan. And ERISA is important because it's imposing these minimum limits that fiduciaries have to meet when they act on behalf of plan participants. Fiduciary responsibility under ERISA, there's a few things that we can think about. So they've got the obligation to act solely in the interest of plan participants and beneficiaries with the exclusive purpose of providing benefits to them. And they've got to do this, they've got to follow that responsibility with an obligation of prudence. And they do that typically by following the plan documents, making sure they are following the written terms of the plan. Another key thing that they have to do that we want to keep in mind when we're talking about, subrogation is they've got to only pay reasonable plan expenses. So they do not want to waste plan resources or plan funds, and they've got to be judicious with how they handle plan expenses. So again, it's not going to be, plan fiduciaries are not going to be limited to just the named plan administrator or plan sponsor. Other parties who are providing services to the plan may be fiduciaries as well. It's going to really turn on what the entity is doing, whether they have discretion to make decisions regarding plan assets.
So Ryan, do fiduciaries have to, agree in writing in some document or contract that they're taking on fiduciary responsibility?
They don't have to. Oftentimes you might see that where there is an administration agreement, services agreement, where someone is actually taking on fiduciary liability or fiduciary responsibility. Now that person, that service provider, is getting paid a fee for taking on that obligation. But no, it's not dependent on some written contract, and frequently entities can take on a fiduciary responsibility maybe without even knowing it. It's just dependent on what actions they're taking in regard to plan assets and what they're doing. So someone who is ordinarily not a fiduciary can all of a sudden become one very quickly if they kind of start exercising discretion and making decisions that they may not have authority to make. And that kind of brings us to the next one, the claims administrator. That is so that's separate from the plan administrator, and I guess it's typical with most self-funded plans. The employer or the plan sponsor just doesn't want to have to deal with the overhead of administering the day-to-day claims, so they hire a claims administrator. Essentially, they're turning over what they hope to believe are just these ministerial duties of processing claims, determining whether they're covered under the express terms of the plan, and then paying them based on whatever the plan document says or whatever the PPO contracts specify. Sometimes that claims administrator can be one of the BUCAs of the world. Oftentimes it's a freestanding claims administration company. And ideally their job is simply to process and pay claims in accordance with the terms of the plan. But as many of you know or can imagine, not every claim is always black and white, and a lot of claims run into certain gray areas, and that's where a claims administrator, if they're not careful, can quickly turn into a fiduciary if they start making certain discretionary decisions about what is or what isn't covered, or they start handling appeals and making discretionary determinations about whether something is medically necessary or certain determinations that maybe are better left for the designated plan administrator or named fiduciary. A couple important terms here are the plan document and the SPD. The plan document is the controlling document. So generally the plan document is going to be this comprehensive written plan document describing the operation, the maintenance, and administration of the employer's plan. The plan document can be written in legalese and difficult to understand for the ordinary participant who might be reading through it. But it's important because Section 402 of ERISA requires that benefits must be established and maintained according to a written instrument. And so there are several requirements that must be in a plan document. And that each plan document must specifically specify the named fiduciary who will have the responsibility to administer the plan. It also must have procedures for amending and terminating the plan. It must talk about the source of the plan contributions. Are they coming from the employer's general assets? Are they coming from contributions from participants? Are they coming from a trust? Are they coming from insurance? And finally, it's got to talk about the allocation of responsibilities between the employer and any insurance carriers or other third-party administrators. By contrast, the SPD, at least in the regulations, is supposed to just be a summary of the key terms. The summary plan description is at least meant to be a document that's going to be written in an understandable way for participants so they don't have to figure out legalese. They can just understand what are my benefits, what are my copay type obligations. So unlike the plan document, which is housed by the employer, the SPD is required to be distributed to plan participants. ERISA is very specific on its distribution and formatting guidelines regarding the content of SPDs and the required style and format, where you have to list things and what you have to talk about. But in effect, because the SPD is summarizing the plan document of course must encompass the content required for the SPD. So we got to make sure that we're not in conflict between the two, that they're not drafted independently necessarily, that the SPD, if we have a separate SPD, which we are supposed to, that it is functioning as a summary of the key terms that are already in the plan document. Now, in many cases with health plans, in contrast to pension plans, the SPD also serves as the plan document. Courts have generally approved of this dual document approach, as long as the SPD that is serving as both documents has all of the requirements for a plan document. Now I know in our practice, we've seen many SPDs that simply don't live up to that. They look more maybe like a benefit booklet, and they don't talk about what the procedures for amending or terminating the plan are. They don't go into detail about the source of plan contributions or all the allocation of responsibility between the different third-party administrators. And so that's where you can run into problems with using the consolidated document approach if you don't meet all of the requirements. But it's just important for you to know that there are two separate documents. Some can be consolidated, but those are key terms, and you'll get a lot of requests from plaintiffs' lawyers out there for both of those documents. So you need to know if your group is using a consolidated document approach or if they have the separate documents. Where should you go? Where should you start looking when you get your plan document or SPD? Just to understand who the players are, what the funding is for this particular plan. My always go-to is there's a plan summary or plan information page, and usually it's right at the beginning or it's all the way at the end. And that page is going to tell you who the plan administrator is, who the plan sponsor is. Where do you send notices of appeal? Who's handling the claims administration? All of those relevant contacts are going to be on that plan information page. It'll also cover the funding mechanism. So oftentimes that's the page that I'm sending to the plaintiff's lawyer to say, here's the information on the plan funding. That's a great page to start. So make sure that that's the first page you're probably looking towards to find that out. Next, the key terms are self-funded versus fully insured. So there are essentially two types of ERISA groups, fully insured and self-funded. A fully insured group purchases insurance through a company like Anthem or United Healthcare or any of the other big insurance companies, while a self-funded group funds the benefits and pays for the employee healthcare out of its own general assets or out of trust that it's funded by its own contributions. So it's very different. You know, one is being run essentially as an employer-sponsored healthcare policy. The other is really, as the name suggests, it's a self-funded plan of benefits that is funded entirely by that employer or union. Knowing the difference is of course critical, because unlike fully insured plans, self-funded plans are never governed by state law and their myriad regulations. Rather, as the Supreme Court has repeatedly held, self-funded plans are able to preempt inconsistent state law that regulates health plans or health insurance. Very important concept. ERISA preemption, probably one for another day, but it's just very important that you know what type of plan you are dealing with. Of course, you may get the question, because most of you are going to be dealing with, I'm sure, self-funded plans, and you're going to get this question from plaintiffs' lawyers about stop-loss insurance. And I just told you that if the plan is funded by insurance, it's fully insured, and they're going to say, well, there's this, you've actually got a hybrid plan. It's in between the two. It's got this stop-loss insurance. Again, we've talked about that in a prior seminar in greater detail, but stop-loss insurance is not health insurance. It's very different. Most self-funded plans will have some form of stop-loss insurance, but the important thing to know is that's not the same as being fully insured. In fact, it still actually means that you're self-funded. But that's just a key distinction there. And then finally, I want to turn to really the last fundamental principle that you're going to be pulling out of your plan documents is the importance of plan language to subrogation. Really, plan language is paramount. You may hear a lot about ERISA preemption, and we could talk about that as it relates to self-funded versus fully insured, but no amount of ERISA preemption is going to save you from a plan that has poorly drafted language or that is simply out of date. Ultimately, there's not going to be anything to preempt, because our language doesn't necessarily cover made whole, or it doesn't cover the common fund, or any of the other issues that will come up in the case. And I say that because one of the important things you need to understand is that ERISA, that lengthy statute that we introduced to begin, doesn't authorize or prohibit subrogation or reimbursement. There's simply nothing in ERISA that says an employer must have subrogation provisions in their plan or must have reimbursement provisions. Now, it certainly makes sense that they do, because we know one of the obligations that fiduciaries have is to control plan expenses, and third-party recoveries through subrogation and reimbursement help contain costs for a plan. So it makes sense that they do have those in there. But you are going to be completely on your own based on what language your particular plan has selected for its plan subrogation provision. So after you look at that plan information page, you want to really go into the plan's subrogation provision. One of the other things I will, just a little tip, oftentimes if you're dealing with a plan that's existed for a long time, maybe with the same TPA, there may actually be amendments in the back of the plan, or material modifications, where the plan over time has updated or amended its subrogation provision, but didn't do it in the body. So there might be a subrogation provision in the plan, but there's actually an amendment to that later on. So you want to make sure that you have all of the important material modifications to to the plan to see if there's any updates to the subrogation provision. So maybe the main argument that we run into, probably the most common, right, is that the plan participant was not made whole by some recovery. And so the made whole, it's kind of a default rule in most states and most federal circuits. So if your plan doesn't have language that says that it has a first right of recovery, and it doesn't matter whether the participant was fully compensated or made whole, you're going to run into problems with getting around the made whole doctrine. So in other words, instead of the plan getting first priority reimbursement, the participant gets first priority recovery, and you can only recover after that point. But again, that's going to be a really important concept. So you've got to focus in and know what the language is in your plan. First thing you do, whether it's a made whole issue or if it's a death claim, you want to get in there and find out what rights you do have, because plan terms can be very, very different across groups. All right, so that's enough about the background. Now that we've kind of touched on these foundational principles of ERISA and ERISA plans, why don't we start talking about the fundamentals of setting up a subrogation file, identifying and recovering on the subrogation claims. Catherine, why don't you take it from here?
Okay. One thing I'll just tag on to the last thing about made whole. If you've got a plan that doesn't have good made whole language, remember that the made whole rule is not uniform across every state or across every circuit. There are a lot of states that have very specific rules about made whole. Whether or not, for example, what the made whole rule in that state cares about are economic losses that have been suffered, whether or not the made whole rule includes things like pain and suffering. So if you're dealing with a case where you don't necessarily have great plan language on the made whole rule, you should be consulting statutes. You should be consulting either your supervisor or even local counsel about how the made whole rule works in the individual state, because that's not going to be the same thing across the country. So turning to
what Catherine meant was call us. We'll let you
know. So the different types of cases that you're going to be handling as a subrogation file handler. Obviously, the vast majority of cases on your desk are going to be basic motor vehicle accidents. Usually it's going to be cars, though there can be other motor vehicles. We get a lot of, ATV or boating accidents. I once had a riding lawnmower accident. Workers' compensation files, product liability, premises liability or homeowners, or medical malpractice. Now, what type of file it is may have significant impacts on your ability to recover. Obviously, some of these cases necessarily implicate a business who did something wrong, who's going to ultimately be the party responsible, whereas some of them are going to be far more likely that just an average citizen is the at-fault party. So in a motor vehicle accident, most of the cases that you're going to be dealing with are going to have personal insurance coverage, perhaps state minimum policy limits. And so those limits are really going to constrain what you're going to be able to get no matter how much the plan has paid out. Other ones, like product liability, may be more likely to have larger insurance policies because those are going to be insurance policies held by companies. You're going to want to look into that in pretty much all cases. So in a motor vehicle accident, was the person who was responsible for the accident in the course and scope of their employment at the time? If that's true, it means that their employer and their employer's insurance policies may be at play, and there's going to be higher limits. Some other issues that you're going to want to seriously take into consideration, especially in workers' compensation and medical malpractice cases, is whether or not the employer group is acting on essentially what the lawyers call both sides of the V. And so all that means is that is the employer both kind of like a plaintiff in that they're looking to recover against a defendant for losses that they suffered, but are they also, in example, in a workers' compensation case, self-funded for those workers' compensation benefits? In that kind of situation, what you're going to be dealing with is essentially the health plan has paid out claims and is just trying to recover from essentially a different bank account at the same employer for those workers' compensation benefits if the employer is self-funded for the workers' compensation benefits as well. Why that's important for you is that, first off, a lot of those plans choose not to, when the essentially member and patient are the same, pursue subrogation at all, because all they're going to be doing is moving money from one bank account to the other, and they'd either rather not do that at all or just handle it internally rather than involving a vendor who's going to charge them a contingency fee or a lawyer who might charge them an hourly rate, because that's just money that they could be otherwise saving. So if you're handling a workers' compensation case and the member and the patient are the same, you want to be finding out early in the file, is this a case where the employer is fully funded for workers' compensation? So they're going to want to pursue their lien because they're going to want to get that money back. Or are they self-funded for both? And maybe even if they have you handle a file, is this a situation where when push comes to shove and a settlement offer goes on the table, the employer is going to choose to waive the health lien in order to secure a more favorable resolution with the employee? Because that happens all the time, especially in cases that we get involved in, where, for example, a court wants to make sure that all the lien holders are a part of the litigation. And so finding out how the workers' compensation is funded is something that you should be thinking about every time you get a workers' compensation file. The other situation where we deal with this pretty commonly is in medical malpractice cases where the self-funded health plan is actually sponsored by a hospital or another medical facility. So you'll end up with a situation where somebody was essentially being treated at their place of work. And so in those situations, if the plan is the provider, first off, one argument you may commonly hear from attorneys is, did any money actually change hands in the first place, or did the plan for treating at its own facility just write down a price? The other issue is the same as you have in workers' compensation. Is the hospital at the end of the day going to incorporate that health lien into any settlement offer that it makes to the patient? Are they just going to try to waive the lien at the end of the day? That's something that you're going to want to be talking to the employer about. The other issue that commonly comes up in medical malpractice cases that you want to be thinking about, and this is regardless of whether or not the employer is the potential tortfeasor, is pretty much by definition, if medical malpractice has happened to you, you were at a medical facility getting necessary medical treatment in the first instance. And so if you've got most of your claims list, most of the value of your case as treatment for that initial date of injury, you're going to need to be going through that with a fine-tooth comb to try to figure out, was all of this actually related? Was there, treatment that we initially thought went fine, and then the patient came back because something seems to have gone wrong? Was it a complication that occurred in the actual original surgery, and so that surgery bill is part medical malpractice, but part what they were doing initially anyway? If you're referring a file to litigation, if you're going to go all the way with these cases, part of discovery in a medical malpractice case is going to be hiring an expert to say, what would this surgery have cost if nothing went wrong in the first instance? Because that's something that the plan would have been on the hook for no matter what. Obviously, in a lot of cases, that's something that you're potentially going to negotiate, and it's not going to get all the way to discovery and expert opinions, but you still might want to talk to somebody, a claims processor at the TPA, if one of them's involved, and say, do you have data on what this procedure typically costs at a facility, at this facility, when nothing goes wrong. You may need to talk to a vendor that does bill negotiation or collects claims data to kind of get that information to figure out what the starting point of your lien really is. Because of course, plaintiff's counsel is going to come back and say, this is what they would have charged anyway. They didn't really upcharge because they medical malpracticed my client. And so you need to make sure that you have the resources available to arm yourself with the data to say, no, if nothing went wrong, this surgery would have cost $10,000, but because of all the stuff they had to do to fix the medical malpractice that happened, they charged us $50, and that's what we paid.
Yeah, and with both of those examples, the workers' compensation example, the medical malpractice example, we're really trying to tell you to start the work early, because if you wait until the end, if you just set those cases up like your normal motor vehicle accident, you're kind of setting yourself up for a really big problem at the end, either in the workers' comp. All of a sudden, you've done all this work, the life cycle is gone, the file is gone. You've been bogged down with this file, but the employer was always going to waive the lien anyhow. So you needed to kind of know that. If you could have identified that a long time ago, you could have saved yourself a lot of work. Whereas in the medical malpractice, there's a lot of issues there with the relatedness and the amount of the lien, that if you wait until the last minute, it's going to be very, very difficult to sort out, and you're going to have very limited information being provided to you in order to make a recommendation to the plan administrator on what it should do with regard to the lien in that case. So start early, budget more time on those files early so that you don't run into the problems that you can't fix at the end.
So different types of cases are going to implicate very different kinds of coverage. Most of the cases that you're going to deal with, there is going to be an insurance carrier on the other side. So in car accidents, in premises liability, in homeowners claims, the first thing you want to be finding out is there some form of no-fault coverage, which is just going to pay for medical bills up front, regardless of who's actually liable for the incident. So in car accidents, often that's either going to be on the patient's own auto insurance policy. Maybe if they were a passenger, it's going to connect to the driver's policy, depending on what state you're in. But you want to be finding out if those are available. In premises cases, in slip and falls at a commercial establishment or some kind of homeowner's policy, those coverages are going to be on the third party's policy, but they're still going to be available to your claimant. Ask about those early, ask about them often. I see I see tons and tons of cases where we get all the way to negotiation of a third party case and nobody's ever asked, is there some form of no-fault coverage involved that could serve to reduce the lien? And that's important for a couple of reasons. First, obviously, if you can get money back for your client early, that's something that they're going to be very interested in. Most clients would rather see those funds come early rather than late if they're going to get them anyway. The other thing is you don't want to be dealing with a situation where that coverage was available, but the entity that has the coverage, the auto carrier, says, we only cover claims that are submitted within 1 year of the date of accident, and because you've been negotiating with a third party for 2 years, either we're going to fight you for the coverage or the coverage just straight up isn't going to be available anymore. And so getting in touch with those parties early can be key. It can also be important because if there's not going to be enough liability coverage, you want to make it's in everybody's best interest. It's in plaintiff's counsel's best interest. It's in the plan's best interest to get those no-fault benefits to the plan because they reduce the ultimate lien that you're going to be submitting. This is also a great opportunity to actually get plaintiff's counsel to cooperate because, again, those funds are going to be available regardless. In many states, the coverage is going to be pretty minimal. You're going to be dealing with maybe $5,000 in coverage, maybe it's only $1,000. But in some states, that can be really meaningful. If you're handling files in Michigan, no fault is going to be a huge deal because on a motor vehicle accident, the no fault coverage is essentially unlimited. And so they should be covering all of the medical bills. If you're dealing with a file in New York or New Jersey, you're likely dealing with at least $50,000 in coverage. And if you handle files in those states, you also know that they're both anti-subrogation states. And so you're going to be dealing with challenges recovering against a third party. Those attorneys are way more likely than attorneys in a lot of other states to put up a fight to your right to recover from the third party. And so if you can get those larger limits, that might be enough to resolve your case, and you never have to deal with whether or not it's okay to recover from the third party or whether the attorney is going to make you litigate those rights. Obviously, you're often going to be dealing with regular liability coverage. That's just what the third party has to cover whatever responsibility they have. If those limits are insufficient, you may be dealing with your own insured's either uninsured motorist coverage or underinsured motorist coverage. While that is technically what's called first party coverage, and you're going to hear that a lot from attorneys, this is coverage that my client went out and sought, it's their policy, why should you get to come after these funds? That's coverage that acts like third party coverage in that it ultimately is designed to cover damages that were caused by that tortfeasor, or by that third party that caused all the damage. You want, whenever you're dealing with UM/UIM coverage, to be looking very closely at the language of your plan document. I've seen plenty of plans that only ever talk about third party liability or coverage of the third party. And so your plan language may not cover UM/UIM. In a best case scenario, and a lot of plans obviously have gone in this direction, they expressly discuss that third party coverage means UM/UIM coverage. And so the other thing that you want to make sure you're doing if you're reviewing your plan document and all of a sudden you're seeing things that say third party claims, third party coverage in the subrogation reimbursement section, see if your plan has a definitions section that's maybe many pages away from the subrogation section that defines what third party means, because that's often where you can find the reference to UM/UIM. It's preferable if you're writing a plan document that you include that information in the subrogation and reimbursement section itself, just so there's no digging, there's no potential oversight, there's no confusion when plaintiff's counsel is reviewing the plan document. But if you're handling a file, make sure you're checking that definition section if the subrogation and reimbursement language, the page you're looking at, doesn't seem to answer the question.
Yeah, just to jump in, if you do have a plan that doesn't have very specific language and kind of just generally refers to third party, you're probably going to run into some issues with the plaintiff's lawyer arguing that you can't attach your lien to the quote first party coverage. But there are, I will let you know, we've got cases here within our database. We know that we're very clearly talk about how no UIM coverage is a third party vis-a-vis the plan, therefore the plan's third party provision still makes sense and still attaches your lien. So if you run into those problems, we do have some authority for you. I will tell you, it just makes it cleaner and easier if we could get that language in the plan. So if you've got groups who are updating their plans or flagging, if you see that for review, that's one of those items that we definitely recommend improving on.
Yeah, and be clear about it either way. I have worked with at least one plan that expressly does not want to recover from UM/UIM. And so if that's the position that the plan sponsor is taking, be clear about that. Don't leave this ambiguity, because all the ambiguity is going to lead to is potentially needing to litigate your rights. And you don't want to do that. You want to make these recoveries, whatever the ultimate amount of the lien is, whatever the lien can attach to, you want to make sure that everybody at the time of settlement understands what everybody's rights are. Sometimes you'll also deal with cases that involve what's called umbrella or excess coverage. And so that's going to be coverage essentially above and beyond that original liability coverage. It's often going to be involved in cases that have commercial entities. So if you're dealing with an employer in a motor vehicle accident, or if you're dealing with a slip and fall on a premises liability case, but don't exclude asking about that coverage when you're dealing with personal automobile accidents. There are people that have umbrella or excess coverage, and you want to make sure you know for sure whether or not that's a source that was available. This is pretty rare, but sometimes you may deal with a case where an individual is making some kind of personal payment because their insurance is insufficient, but they're concerned that they may have enough assets that if a lawsuit is filed against them, there may be something to attach there. The two that you'll be dealing with a little less often are restitution. So that's when the individual committed a crime, when the tortfeasor committed a crime. So assault cases, some drunk driving or driving under the influence accidents. You may deal with a situation where there's an underlying criminal case. And so you can essentially write to the court and say, when you sentence this person, we want to be included in any award for restitution. Courts tend to go one way or the other on that. I've either seen them deny it or award essentially a token amount that they believe that the person actually might have the capacity to pay, either immediately during their time in prison or after their traditional sentence has concluded. Or I've seen cases where somebody who has no ability to pay whatsoever is faced with $1 million restitution award. Coordinate with the courts about that when you're dealing with them. As a practical matter, they can require a little bit of legwork. Sometimes any restitution is going to go to the court and then the court's going to forward it to you. Sometimes all it means is that you've got, you, the plan, have a judgment that you could choose to attempt to enforce the way you would often enforce a judgment, though that's often not going to be worth the price. And then the last kind of case you might deal with is these mass tort settlements. So if you've got a case involving some kind of defective medical device like a hip replacement or drugs, and just something important to think about in those cases is that often settlements are structured in such a way that people are put into certain classes, and then they get a certain amount based on what class they're in. And so the important thing to think about there is that the award may not be essentially as individualized as you might expect when working in other cases where an attorney puts together a demand package and lists out, you know, these are my client's damages, this is how much they think they're due for pain and suffering. The mass tort cases may simply involve a more blanket, okay, because you were diagnosed on this date, you're entitled to $20,000. Different sources of information. When you get a case and you are trying to figure out what happened in the underlying accident, does the person have an attorney, what's going on here? Obviously, one of the first places you want to go are publicly available court records, especially, you know, if you're looking a little bit after the accident occurred. Court records aren't going to be as helpful if the accident was last week. PACER is public access to all of the federal dockets. And so personal injury cases don't happen there quite as often, but especially if they're higher value, they might. Westlaw has pretty great access to state dockets in their docket section. Don't be looking at just where you would go to look for case law. Specifically, go to the docket section, put in the person's name. A great trick is to do their first name and then do a \3 and then their last name. What that does is it looks for their first name within 3 words of their last name. And so if they've got a middle initial or a middle name, it's not going to exclude those results for you. Doing a basic Google search will often reveal some kind of GoFundMe page or some other social media post. Those have been kind of upticking in terms of sources of information in recent years. Many police reports are publicly available. If you have a state that consolidates those and there's one site you can go to, they can be a great resource. And also just Googling for news reports about the accident can be important, and those can all help you figure out who the responsible party is. If it's a police report, it'll often have insurance information. So these are the sources that you want to go to if you literally know nothing, but are trying to figure out who to put on notice, what are the basics of the accident, what should I be expecting going forward. So you've figured out who's involved in the case. Who do you want to make sure that you're putting on notice? Obviously, the patient or their parent or guardian, if the person is a minor, and if you know the person is represented by counsel, obviously you want the notice letter to go to the attorney. This is a represented person. The communications should be going through counsel. You should also be putting the adverse parties on notice. You want to put the insurers on notice. And if the case is in litigation, you want to make sure that defense counsel knows that this lien is out there. If you know that there's a lien resolution group involved, make sure that they're getting all of that as well. One of the things I wanted to stick in here is how should you be thinking about notice letters differently if the entity that you are representing is a stop-loss carrier? So stop-loss carriers, like we've talked about in our stop-loss webinar, typically don't have rights directly against the participant, and so aren't going to be directly involved in the underlying litigation. But if you are representing a stop-loss carrier and you know that you have paid claims related to some kind of third-party event, you want to make sure that the TPA, the subrogation vendor, and the plan itself are all fully aware that you are going to be due reimbursement if and when they make some kind of recovery from the underlying incident. Because I've dealt with so many cases where the plan is suddenly surprised by that information after they've recovered, and it just creates a lot of resentment between two entities that should be working together, and it creates a lot of situations where the stop-loss carrier isn't as involved in the case as they should be, isn't dealing with reductions as often as they should be, and may end up with less recovery as a result. So what are you putting in your notice letter? Obviously basics, make sure that the person that you're sending the letter to has enough information to tie this to something in their system. So if you're writing to an insurer, you want to make sure their claim number goes in there, the date of accident, all of that. Make sure that you are letting, especially plaintiff's counsel, know what kind of plan this is. If you are dealing with a private self-funded ERISA plan, tell them that. That said, don't guess. Don't tell them it's a private self-funded ERISA plan if you're either unsure about that information, or obviously if you know it's not. You should be including plan language as often as possible. First things first, you're going to end up getting those questions. Eventually, any responsible plaintiff's attorney is going to ask for it. Put it up front. Say, we disclaim the main whole rule. We disclaim the common fund doctrine. Our rights apply to UM/UIM coverage. Put all that in as soon as you can get it. If you need information in order to set up your file, to put other parties on notice, don't just send a generic letter that says, hey, we have subrogation rights, call me. Tell them, I need to know whether or not there's no fault coverage available that we should be coordinating with. I need to know the adverse either attorney or insurer's information. The other thing you want to do when you're setting up your file, whether you do this through correspondence or whether you do it with a phone call, find out if there are concerns initially that might reduce the recovery. So like we talked about in work comp or the medical malpractice settings, is this a situation where the whole lien might not be related? Is this a situation where the plan and the third party that the patient is pursuing are the same entity? Is there some question about whether or not the third party was fully liable? So obviously the most common example of that is slip and falls. Usually the responsible party will say, you know, you tripped over your own 2 feet, you should have been looking where you were going, this is partially your fault. Are there concerns with liability limits? You want to make sure that you're noting those at the beginning of handling your file, because again, the last thing you want to do is handle a case like it's a $2 million case from day one and put a huge amount of resources into it, only to find out 2 years down the line that the maximum recovery is going to be $25,000. You want to make sure you're preparing the plan for that and that you're handling your files accordingly.
Yeah, and we're also creating a file, we're creating a record. So it's important to ask for this information, even if they don't initially send it, to have documentation that you've asked for this information may come in handy down the road to show that, hey, we tried to get this information, but these guys just wouldn't give it to us. So it's important to create a good record for your file.
Yeah. And don't assume that they're just going to know what you need. And so the more specific you can be, the better. Some red flags that you might want to be thinking about. Every once in a while, you'll get a file where somebody says, I'm represented by counsel, and it turns out to be a criminal attorney. Does the plan need to consult with someone involving criminal act exclusions? A lot of times with motor vehicle accidents, the involvement of a criminal attorney can suggest that the patient you're handling might have been intoxicated at the time of loss, and so that's just something that you want to flag for whoever's responsible for that at the plan. Are these benefits that they should even be paying in the first place? A lot of plaintiff's counsel obviously can be very hard to get information from. Some great ways that I found to secure cooperation. First and foremost, especially early in the case, pick up the phone, try to get the attorney to just give you a candid discussion and assessment of the case. Most of them will, if you can catch them with a free moment, and they may include details that they're going to be unlikely to respond to in a short, like in an email, you might just get the case is pending. In a phone call, I think you're way more likely to get, we just sent out discovery requests, or, at this point, we've made a demand of X and we've only gotten a response of Y. And so a great follow-up question there, if there's a really big difference in those two numbers, is there a liability issue that I should be concerned with? Are they disputing, for example, that a certain surgery is related to the accident, and so I should be thinking about, this might potentially impact my lien, depending on how this shakes out at the end. Once you're doing more standard follow-ups, email addresses are always great. And one thing that I found really helpful, especially if you're dealing with paper, if your policy is either to mail or to fax requests for status, put something that they can just circle. This is still pending. Call me back in 3 months. They're way more likely to respond to that than something where they have to physically write out a more detailed response for you. So give them the option. Obviously, put a line, be like have an option for, they can circle, call me, let's discuss. But the easier you make it for them to respond, the more likely you are to get those responses, every 3 months, even if the litigation is going on, even if the underlying litigation is going on for years. When you are reviewing your claims lists, things that you should be on the lookout for are there gaps in treatment? Do you seem to be missing anything obvious? Like I've had cases where there was no treatment on the date of loss for a car accident and there should have been. How are you getting this data? When was it last updated? These are just things that you want to be thinking about, because they may signal to you that, if there's a big gap in treatment, is there a relatedness issue that you need to be thinking about? If there's no treatment on the date of accident, do you need to be talking to either the plan or the member about where all those medical bills went? Are there claims that might be lagging behind the others for some reason? This issue could be its whole own webinar, but if you know that you deal with reference-based pricing plans, you need to be treating those liens very differently, because even if you've got a paid amount on your list, that might not be the final number. That might be the initial number that was sent to the hospital, and those lists are still being negotiated, essentially. And so if your plan is working with an RBP vendor, you need to know that, so that when the case is settling, you can make sure that any claims that are still in negotiation are accounted for, because the last thing you want is to find out that the plan is making an additional $200,000 payment that you didn't know about when the case was settling. Be extremely careful anytime somebody asks for a final list. Obviously, you want to be putting the burden on plaintiff's counsel to say, you know, I can represent that this is all the treatment that my client received related to the accident. But if there's recent treatment, if there are claims that are pending, if there are claims that are denied, those are all things that you should be dealing with, obviously, as early as possible, but at the latest, when you're dealing with any kind of request for a final list.
Yeah, be careful with the word final, just because, you know, we've seen it, especially in Florida. Attorneys will sit on the bills until their third-party case is settled or the initial settlement is finalized. They'll get you to say, here's my final lien, and then the bills will magically appear on your desk, and they'll say, well, Florida statute says that we don't owe anything more after after the third party recovery is there, and so you're out of luck. You need to pay these. It can get really tricky, yeah.
So last but certainly not least, things to be talking about in reduction requests. Obviously, do you have a final lien? If you have reason to believe that the person is no longer on the plan, figure out whether that means that the plan has either switched vendors or TPAs, because if that's what has happened, the plan may still be paying claims with that new entity. And so what you want to make sure you're not doing is accidentally prejudicing the plan's rights to pursue any future claims that they're paying. And so that may mean essentially that there's two liens. It may mean that, you need to talk to the plan about getting the claims list from the new TPA or something so that you can add that onto your lien. Whatever it means under your contracts and your relationships, just make sure that you understand if that's happening.
Yeah, I mean, like, you've got heavy treatment, all of a sudden, 1231, it ends. Like that's a red flag that maybe they have switched TPAs, and you need to follow up on that.
Anytime you're dealing with a reduction request from an attorney, get those details that you know you need to go to the plan with in writing. Attorneys have obligations to make sure that they're being truthful, and make sure we're going to send out these slides. Make sure that you are asking them about each and every type of coverage that's listed on that one slide, and make sure they expressly answer yes or no to each coverage. I have a form that I use where plenty of attorneys will just write in the amount of the liability policy and they'll leave everything else blank. And when I go back to them and I say, I can't go to my client until you fully complete this, you would be shocked at the number of times all of a sudden there's an umbrella policy, there's UIM money available. The number of attorneys who are going to lie to you in writing are exceedingly rare, not that it never happens, but there are a lot of attorneys who are going to be vague and hope that you won't notice. And so don't get caught in that. Obviously, if you're going to be in negotiations for a while, or there's some bigger dispute that needs to be dealt with, make sure that you get in writing that the funds are going to be held in trust. This is the ABA model rule. Most attorneys do have an obligation to hold those funds.
Wow. Well, thanks, Catherine. That was a quick ending. I know we ran over a little bit, guys, but that's really the first in our kind of Subro 101, ERISA 101 sections. We'll probably do another one in the coming months, but I do want to kind of prep you for next month. So July's webinar, it'll be July 26th, same time. We're going to kind of take you back to those in-depth topics, and we're going to talk about subrogating fully insured and non-ERISA plans. So we'll be talking a little bit in detail about ERISA preemption. You've got to kind of go down pretty far for these fully insured plans. and then we'll kind of, give you an idea of how to best handle these non-ERISA state law, whether it's self-funded non-ERISA or fully insured non-ERISA, because there are some tricks that you can use, arguments that are proven even if you're in an anti-subrogation state per se. So look forward to seeing you next time. Feel free again to hit us up with any questions. We'll be happy to answer those, and we will forward around the PowerPoint so you guys all have it. But enjoy your summer, and we'll see you next month. Thanks a lot.